Good day, Crime Talk aficionados. We have a quick show for you today, and it's all about the Bryan Kohberger motions hearing today. So let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out on any of your favorite podcasting apps. Now, we have a very abbreviated docket today. Only one matter. Bryan Kohberger. And things didn't go well for Bryan Kohberger and his team at the motions hearing there in Ada County in Boise, Idaho today. Now, let's go through a lot of these. Now, if you want to check out the entire motions hearing, you can do that. We'll put a link to that, all right? It's pretty interesting, but I'm going to give you the highlights so you don't have to, because we just spent little over 8 hours and 8 minutes of time on the Bryan Kohberger matter today. So first, the defense had filed a motion regarding inflammatory evidence. Judge is going to say, well, we'll take that as a one-by-one type of thing. We're basically referring to pictures. Don't use the word murderer. Don't use the word sociopath or psychopath. Prosecution says we don't intend to go there. So not really a big deal. It was kind of a peremptory thing. I don't know why the defense filed for that. That would certainly be inappropriate, and nobody intends to come to any of those conclusions as it relates to that. As it relates to the motion in limine filed by the defense saying, don't bring up anything about, the prosecution is trying to kill their client. Everybody agreed that the appropriate language is that which is in the statute and the appropriate jury instructions. So the prosecution isn't going to do anything that's going to result in a mistrial. As it relates to 404B evidence of other wrongs, crimes, misconduct, things of that nature, the judge basically said, hey, a lot of this stuff isn't 404B. For example, his prior academic paper as to his knowledge of how crime scenes are investigated and how it could potentially be used to show that he has knowledge of what to do to try and leave no trace behind. So that really wasn't a big issue. The only issue that really came out of that was the traffic stop of Bryan Kohberger on August 21st, 2022. This is a video where he was stopped, and in this particular case, it was at night. He was in the same vehicle that he's allegedly driven on the night of the murders. It was at night. He didn't have his seatbelt on, so the defense said, well, you can't bring the seatbelt. That's 404B misconduct. Kind of a disingenuous link. Oh my God, it's a gateway crime. You don't have your seatbelt on. The next thing you know, you're going to be committing quadruple homicide. No. So that would more than likely be redacted out, but it goes to identity. It goes to Bryan Kohberger confirming who he is, confirms that this is his car, his title, registration, things of that nature. So more than likely that's coming in with some possible redactions. Basically, the argument was, Judge, it is prejudicial because it shows Kohberger, his description of the car, his residence, the address, telephone number, and so I understand why the defense doesn't want it in. So does the prosecution, so does the judge, but it will more than likely be coming in as well. Then we took up issues as it related to sequestration orders. The fact that the defense thinks it's unfair for the prosecution to endorse Bryan Kohberger's family. Therefore, they can't sit in the gallery during the trial. Obviously, the defense wants a sympathetic people there on behalf of Kohberger, that his family still cares about him, right? Nothing worse, I can tell you, going to a serious case and there's nobody for the defendant on your side of the courtroom. That's always a problem. Anyway, they're going to try to work through that, and if they need any one of Bryan Kohberger's family members to testify, they can try to take them out of order so that they can sit there in support of Bryan Kohberger if he needs to do so. Okay? I think the argument that the defense made was a little bit of humanity here, Your Honor. And prosecution said, hey, they're on the witness list. Not sure which one we're going to call yet. It did kind of come out that there was one member that may be called to testify, possibly the one that maybe even tipped off some law enforcement, perhaps. We'll have to wait and see. Then we went into a motion as it relates to aggravation, as it relates to the death penalty and autism as an aggravator. Basically, not really an issue. Talk about some expert that the defense has, and some people could consider his autism. This kind of goes to a motion that was later on in the day where the defense wants to be able to explain to the jury that he has autism. So if you see something weird or you have some weird mannerisms or things he can and can't do, you should consider that. The judge says, well, they're going to be told they can only make their decision based upon what comes out of witnesses' testimony and items that are admitted into evidence, and nothing that takes place at counsel table. And the judge kind of noted, I've seen him in court. I haven't seen anything irregular, so I'm not sure why you want to make a big deal about it, but I'm assuming the defense wants to do it for sympathetic purposes for sure. So that was it on that. Then there was a talk about the investigative genetic genealogy. They're going to work. Both sides are going to work to make sure that it is as subtle as possible, that it was only a tip and nothing more, not some other criminal conduct that the IgG came in. I do think is a little ironic. The defense made such a big deal about IgG, and now they don't want it to be mentioned in any way whatsoever. I get it. It was litigation. They were doing what they thought they had to do, but that's what it comes down to. Alternate suspect motion. Now, the defense has said that they're working on a tip that, based upon some information that they found in one of the tips, they're investigating it. Prosecution says, we don't think so. We've looked at all of those. They turned out to be nothing. The defense thinks, hey, we want time to offer a alternate suspect theory, possibly a witness. Now, remember, to offer an alternate suspect, you have to be able to say who it is, basically that they were there or present and had opportunity to do it, and they could have committed the crime. You can't just accuse the neighbor. Well, there was some a glove out there, and it was black, and the neighbor had a black glove. He probably did it. You can't accuse people of that unless you actually have proof of that. And so there was some talk about the case law and the pre-existing conditions, but as of right now, still investigating, no alternate suspect. I don't think we're going to have an alternate suspect by the time we get to trial as well. But the defense basically says we'll bring it up if they need to do it. There was a whole lot of talk about the DNA evidence, touch DNA. What is the meaning of it? Ultimately, the judge says, I'm not going to exclude any of this. Your own expert defense used the word touch DNA. Now you don't want the touch DNA evidence to come in, but it's just a term of art, and it can be explained by questioning. And the judge basically said, hey, our jurors are smart, ladies and gentlemen, and we try to, sometimes dumb things down so much for them, but that is not the way it is. There was talk about whether they should be excluded. The defense wants all the DNA excluded as it relates to DNA found under the fingernail of one of the victims, basically because the lab said that it wasn't a great enough amount to say that, that it could be identified as somebody's, therefore it's an exclusion. But the prosecution says, hey, there are protocols that the lab, as well as one of their experts, say that they can't be excluded. So therefore, they think that it's of some relevance, and it does go, so it's inclusive, so to speak. And so therefore, they want to be able to say that, goes to their investigation, that they looked everything they could try and do. So ultimately, the defense said that a prosecution witness shouldn't be allowed to go into any of that. And the judge said kind of what I said, sounds like cross-examination. And the judge was going to allow the expert to testify, and they can deal with it on cross-examination or call their own witness. The motion as it relates to the make and model of the suspect vehicle. Defense says, hey, this is circumstantial evidence. There's no continuous drive thing, and we don't want the experts to say that this is the car. Judge says, well, he's going to testify as to what he did, why he thinks it's this one, but he's going to be allowed. The prosecution experts will be allowed to discuss that. Anyway, the judge said he would issue an order about what they can make as far as conclusions about the car, but they will still be able to refer to the vehicle as suspect vehicle number 1. Then they took a lunch break, and then there was the testimony about the bushy eyebrows and who should be able to testify. Judge basically said he'll take it under advisement, but it sounds like it is coming in, as well as the photo as it relates to Bryan Kohberger afterwards. Then we had the motion as it related to the 911 call, as well as the text messages. Prosecution says it's all present sense impression, therefore it's not hearsay. The judge kind of pushed back on that and said, well, it's not all present sense impression. It's not all excited utterance. So basically what is going to take place is the judge is going to wait and see. It depends on how the context of these text messages come out. It sounds like a better part of the 911 call will come in, but there's going to be redactions that are going to be made. Then we had the great dollhouse debate. That's right. The prosecution is creating a three-dimensional dollhouse of the murder scene house, and the defense says, no, you can't do that. And the judge is kind of scratching his head and saying, well, this is just a demonstrative aid. It's going to assist the witness explain what took place, what they did, how they did it, where it was in the house. It's not going back admitted into evidence. So what's the big deal? The defense was like, well, Judge, we haven't had enough time. We asked for this years ago, and they said they're going to do a scale model or something. This is not to scale. And the judge is like, it's a demonstrative exhibit. What's the difference? Like I talked about on my show last night, when we used to put up a big piece of, paper and people draw the outline on the board and they explain what they did. And they went from here and then they went from here, and it doesn't come into evidence, but the jury gets to see it. It'll assist in explaining their testimony. So that is coming in. I didn't really understand that. I would think that the defense would just try to use it to themselves. Next, the other big one, self-authenticating records kind of got pushed off a little bit because some of the certifications aren't done yet and the time limit's not ripe for issue. So the judge said, let's deal with that at a later date. Probably the biggest one, no alibi instruction. Okay. The prosecution has said, hey, according to the rules in Idaho, the defendant, need to provide an alibi. The defense says we can't provide an alibi. The best that we can do is have our phone guy testify that, at 2:50, we believe that Bryan Kohberger was in this area based upon that. But they have nobody that's going to come and testify that at the time of the murders, Bryan Kohberger was not at the crime scene. He was somewhere else with them. The judge said, at this point, I don't see an alibi instruction being given. The defense basically says, we have no alibi. We have a partial alibi, which is the phone records, which will show that at a certain time before the murders, the phone went off. The phone came back on after the murders. They're going to try to say, well, during that time, obviously my phone was off, but I was still just driving around looking at stars, and don't believe that evidence that is Mr. Kohberger's car driving around the neighborhood. The next issue was these time advance records for AT&T. This got the judge fired up. Okay. The prosecution has submitted stuff saying, listen, we want one of those same records that the defense is asking for. They don't exist. We didn't have them. There was nothing on our part to not get them. They just simply don't exist. And yes, now they are much more prevalent and they exist now, but not at the time. There's no bad faith on our part, Judge. Hell, we would love to have them, is what they said. And then the judge called out the defense and said, well, your expert, this Cy Ray guy, he made some pretty bold statements, that these cell phone records exist, makes this big report, but then doesn't really back up what he's doing. The judge says, I don't really like that, because if what he's saying is true, then people on this side of the room, could be in some big trouble, and they could potentially be losing their law licenses. So unless you've got something more to back it up, you're not going there. Okay. So cell phone tower stuff doesn't exist. The defense kind of got beat down on that one as well. We also learned by the judge asking questions of the defense that they have an expert that will testify that they believe that at least 2 people were required to commit these murders and that there were at least 2 weapons involved. Obviously, we haven't seen those reports, but that will be interesting if the defense actually goes there. The defense is also not going to challenge the intoxication results of any of the victims in this particular case. Then there was a discussion about the cell phone and digital data discovery. The defense saying it's not been included and this wasn't anything that should be admitted. The judge says, as their opinion, they can talk about it. We also learned that at some point, and I got to go back and double check this, but they said that they've looked at the data from the people that were in the house, the victims. It says it looked like 3 people looked at those digital data. No connection between Kohberger and the others. And I have to go back and look. That's what my notes say. But then there was something about, was that everybody, others, or maybe one minus the other? So we'll have to wait and see on that. Anyway, the defense basically wants to limit all experts that are bad for them. I get it. This really came up when it came as it related to the Amazon click activity. It's coming in. The judge said, I have no basis to exclude this. And the data is what the data is. And if somebody comes in and says, this is what the data is, if you have somebody that believes that the data is different, then you can call them and you can cross-examine the prosecution's expert. But there's no basis in which to exclude it. Now, the prosecution still needs to get that evidence in. There's where you have to go. So once again, defense kind of got beat down on that one as well today as well. Then the afternoon break, going back to the autism as an aggravator, mental health condition, etc. We talked about, whether he had some motor skills, and it sounds like as a young child, he really struggled. But then you have to judge him and says, well, was this all before he was in his PhD program? And I get it. I mean, some people with autism function differently. I think most people have run into somebody with autism spectrum disorder, and they may have some mannerisms, some demeanors that are different, but it doesn't necessarily mean they cannot function and not know what's going on. The defense basically has made it sound like they cannot even prepare with him. His demeanor and mannerisms are so outrageous, and his ability to go over something is so hard that they frankly just can't even prepare, and they are practically ineffective as it relates to preparing for the penalty phase of this trial. And I know you can't read too much into it, but because you have to prepare for the penalty phase of this trial, because if it takes place, you're rolling right into it. You don't get to wait like another year and say, oh man, we lost. You have to prepare for it. So they have to prepare for it, but their conversations like, at the when we get to this phase, Your Honor, almost like it's a conclusion. Maybe it's just me reading too much into it. I don't know. But I think I would try to qualify that as if they got to the penalty phase, just to let everybody know we're fighting and we're not conceding anything. Okay. Then, like I said, we got to the issue as it related to the Brady violations, basically saying, please strike the death penalty because there is just too much discovery. There's no way we can get into it. It's all the prosecution's fault. Judge says he'll take it under advisement, but he point blank asks him, says, is all this, this 68 terabytes of discovery? And the prosecutors say, listen, Judge, we've tried to review everything. We don't believe that there's anything exculpatory that we can say, oh, you haven't found this. Here it is. The prosecution would have that obligation to turn that over. Okay. And the judge asked him, well, why haven't you asked for more resources? Why haven't you asked for help? Why am I just hearing about this now? Their argument says, hey, this is like the Lori Vallow trial, Judge. Too much discovery violations, dismiss the death penalty, because that was dismissed on a due process violation, not a Brady violation. Judge said, hey, totally different circumstances. I think the judge, he said he was going to take it under advisement, a written order, because that's what he has to do, because this is a death penalty case. But I ultimately believe that will be denied. So basically what it comes down to, the judge said, if it's admitted into evidence, it's legal and competent evidence, you can challenge it, but it's not getting thrown out in any way. That is the recap of 8 hours of testimony, ladies and gentlemen. I did it. I watched it, so you don't have to. But if you want to watch it for yourself, we'll put the link below. That's all we've got for you today. Have a wonderful day. We'll see you next time on Crime Talk. And remember, the Constitution matters.